personnes, mais dans le cas où vous voulez annuler ou vous le déplacer,
en même temps, j'ai une amie qui vient, mais en même temps, je me suis dit, elle viendra à l'université à Véro, j'enseigne.
Ouais, c'est vrai. Ouais. Prenez votre temps pour regarder. Pour l'instant, disons-leur ça, avec les 2 cours à l'ENC. Et puis on regarde d'ici la semaine prochaine ce que vous voulez. Comme ça, ça ne fait pas trop d'infos après. Il ne faut pas qu'on crée de confusion.
Oh. Bon, on commence. So, good afternoon. Welcome to this course on WTO law and practice. So my name is Gabrielle Marceau. I'm Canadian, French-Canadian, and I'm also, in addition to giving this class and being associate professor at university for some 20, 25 years, I'm a civil servant at the World Trade Organization, the WTO, where for some 20 years I worked in disputes. And in the WTO system, one characteristic is that the arbitrators, panelists we call them, are always given a team of lawyers to assist them with disputes, because often they have another job. Being panelist or arbitrator in a WTO dispute is traditionally not paid. It is now paid a little bit, but the compensation is that the system gives them lawyers to help them do the research, the drafting, etc. So this is what I did, and this, of course, influences the course that I'll share with you. Since it's WTO law and practice, I will often try to refer to cases, real cases, in the explanation of the provisions. My assistant, Felipe Griot, well, he has a second name in addition to that, being from Colombia, will be with me, assisting me and helping you, being available. He will say a few words about how to reach him. As far as I'm concerned, you can always contact me by email, and we can meet or speak over the phone or arrange a meeting before or after this class. I don't have an office in the building, but we can easily find a way to meet. So today, I'll continue to say a few things about logistic, organization, exam, and all this. And we will immediately plunge into the substance and start with the history, etc. And there will also be a few comments from Felipe, before we do that. Please feel free to interrupt me. We have 12 classes in the program, and therefore it will be 12 themes, for instance, and we'll go through the syllabus together a bit later. We will have a class where we talk about subsidies. What are the rules on subsidies? We'll have a class about what are the rules or special rules on intellectual property, etc. So there are different classes, and each class deals with a theme. There's also, this is relevant because it affects the way the exam is done. So in this class, it's an oral exam, that is to say 15 minutes, like other oral exam. But the difference is that you will receive, all students receive 10 days before the exam, the questions for each theme. That is 12 questions or about, sometimes there are 13. So you receive the questions, and you are invited to prepare the response to those questions in groups, ideally. And believe me, it's very obvious when students do not prepare in groups, because there are often arguments that come in the context of a brainstorming together. If you want to prepare your questions in group but you don't know anyone, you contact us early on and we will connect you. It's just a plus. Of course, I'll come back to you before the exam, but that's essentially the way it works. You receive 12 questions, you prepare with others 12 questions. The day of the exam, I know some of you have never done oral exam, but the day of the exam, what happens is that you get in the room and then you will pick yourself 2 questions in a basket, 2 questions, and these will be your exam questions. You have 15 minutes to prepare those 2 questions, and then I will ask you the questions and ask you questions about the question, etc. This is an open book exam. You can bring everything you want, but believe me, it won't be useful, because in 15 minutes, I've been giving you 10 days to prepare. You have to know the answer. And very often we hear things, oh, we were in group of 3, I didn't prepare that question. Well, too bad. If you share the preparation of the response to question, it's very good, but make sure that you know as much as those who are in your group responsible for the questions. Questions can be a bit theoretical, but they can also be practical. So the advantage is that there's no surprise. And serious students who prepare do very well because they have prepared their answers, etc. So that's for the exam. If you have questions, you ask. There's usually a class of preparation for the exam. We can look at a few questions. Felipe would give that class, but then we'll see later on. No questions about that? Classes take place in person. There's 1 or 2 possibility that I may not be able to come and I'll do it virtually, but so far, none. So all Thursday lunchtime, we would meet here. Next week, for example, I cannot be here, but I asked one of my colleagues at the WTO who deals exactly with the topic that we will talk about, the rules about access when governments at the border refuse or accept goods. So he will be here in person, Felipe will be here, but me, I'll be connected electronically. There's also, if you want, and we'll decide that probably after the second class today, if you want a visit at the WTO that we have so far planned for either, it has to be a Saturday because you're too big a group, so either 21 or 28 November. And on that Saturday, what happens is that we have 2 classes on that morning, which has the benefit before the visit, or we do 1 class, an hour visit, another class. The advantage is then that we will finish the semester instead of 19 December, I think, the 7th December. That is, we have only 1 class in December. So we finish the term earlier because there's 1 Saturday where we do 2 classes. So let me just check that to see whether you have an interest. I'm myself happy if we continue until whatever the date, 19 of December. I'm here, but usually students like it when we finish a bit earlier, and mainly like the visit of the WTO, and I use it to add to classes. So in principle, is there anyone objecting to a visit to the WTO on a Saturday? That is to say, we would meet there Saturday at, I don't know, 8:30 or 9, something like this. 8 o'clock if you have the courage. Is anyone here opposed to this? And then we'll check which Saturday is better for you. And then I need to request permission to make sure that it's all okay. We would confirm that, but usually it's possible. Anyone objecting in principle a visit and this scheme where you have 2 classes on a Saturday and finish early? And if I say 21 or 28 November, are there people who are not available on 21? Anyone not available on 28?
Sorry, it's just the 21st or 28th of November, it's a Thursday.
Oh, well,
Yeah, so
sorry. It's a mistake. So which date is it?
yeah, actually, if you check, if you go directly to the
What's the date of
syllabus,
the Saturday?
23rd. So the
Sorry.
course, the Thursday before is the 21st, and then this Saturday you should have class chapter 10, digital trade, and chapter 11, trade and environment. So
Right,
it's
they want
correct
to
here.
know the date.
I'm sorry?
23.
23, yeah.
Or 30. Yeah,
Or 30, exactly.
that is. Sorry, I made a mistake. 23, is anyone not available on 23 November? And what about the 30th, the next one? And is there a preference for one or the other? So let's do it earlier, 23. So I will check immediately whether we can come on 23 at the WTO. And a class here is usually an hour and a half, as you know, twice 45 minutes. So it would be about that, 2 classes of an hour and a half plus an hour of visit, 45 minutes an hour. So you plan about 4 hours, 8 to 11:30, because when we concentrate classes, it goes a bit faster, 8 to 12, let's say, or 8:30 to 12:30. So let's take that for granted, and I'll double check and we'll confirm next week. Other logistical issues?
Hi, so as Professor Marceau said, I'm Felipe Grillo, your this class assistant. So, well, first of all, you maybe don't know it, but it's gonna be very likely the last course at UNIJ, at least for now. So it's Professor Marceau's last year. So I hope this will be a privilege for you all. I'm sure it will be. And usually students like very much this class, so I'm sure it's gonna be the same this year. So just quickly, some last admin stuff. If you have any issues with your Moodle credentials, because usually there's 1 or 2 students who have issues, mainly if you come from another university, let me know by email, and I'll try to help you out with that. Same for media server. So usually all classes are, not usually, for sure, all classes are recorded, and you'll have access to that on media server a couple of hours after the class. Same, if you have any issues with media server, let me know, but it shouldn't be the case. Even if you come from whatever other Swiss university, you should have access because it's completely open this year. But let me know by email if you have any issues with that. What else? I don't really have let's say fixed open office hours. You just, if you have questions or whatever you want to ask regarding the course or admin part, just send me an email and we'll try to schedule an appointment or something. But there's no specific time during the week where you can come. Just in case, my office is 4087. You can come and knock and see if I'm there, and you have a quick question, it's fine, but usually it's better to send an email and we schedule that. It's a bit more organized that way. Yeah, that's it, I think.
Presence. So this is a class, like most class here, where you are expected to be present in person. And in fact, there's a bonus on presence, and the presence will be taken. And if you attend in person 10 out of 12 classes, you get a bonus of 0.25 at the exam on 6. This can make a difference between, 5.5, 5.7, and a 6. As I mentioned, this sort of exam values work and preparation. So you tend to have, as a result, a good group of students who do very well because they did prepare the questions, and others who think it's easy because you get the questions in advance, they don't prepare so much, and then they're surprised. So I only encourage you to prepare in group those questions and to be in class, and it's Felipe who each week will prepare this list where you are now being invited to put your name, and you can get a bonus. Are there other questions? I mean, I will go now through the syllabus with you briefly, just to show you what is expected in terms of reading and preparation, and what is not mandatory. I was told that each student, I should expect that they spend 3 hours a week preparation or revision for each class. I know that not everybody does invest this time, but this is a bit sort of the criteria that I was given because of the level of this class. Are there any questions about what we've said so far?
Hi, Professor. I would like to know that so we are recommended to prepare in groups during the preparation of exams, but when we take the exams, we take them individually.
Yes.
Okay, thank you very much.
Completely individually. And I'm telling you, that's why I mentioned the trap. Let's say you're 3 or 4 and you divide the 12 questions, 3 each. Make sure that you also understand very well the responses prepared by your colleagues. And this I will all repeat it when we're closer to the exam, but I usually say that if you write a response to a question of exam as your preparation, you should count about 2 pages response, 2 to 3 pages. You can bring those pages with you at the exam, but you can be sure that if suddenly you just read your response, I will force you to sort of take you out of your security zone and make sure that you understand what you're reading. I know that English is not the mother tongue of many of you. It's not mine either, so I'm very sensitive to this difficulty, but this is why you can arrive at the exam with bullet points, for instance. And always bring, I will repeat, always bring your WTO agreement with you. You can bring your computer, your iPad, anything. But you need the agreement because if you have difficulty with the question, I will ask you, what does Article 3 of GATT says if you have difficulties? And reading it will often help you put things back in context. So you need to, it's open book, but make sure you have the basic material that you will know very well by then that we'll go through. No question? Yeah? Can you speak louder?
How many people are there in the group?
As you like, as you like. You can be 2, 3, 4, it doesn't matter. You form your own group with your own colleagues or friends. It's just that the benefit of the group is not that it reduces your work. It's that you have someone else who sees it differently. And very often somebody will respond to a question and I'll say, oh, what about that? And then the person will say, oh, I didn't think about that. And then I would say, so did you work in group? Oh, no, because I didn't know anyone. So the group is to be challenged and to make sure you have a real brainstorming. And also it's the reality of international economic law now, the reality of issues like climate and trade, where you always have experts from different areas working together, and not only one discipline is sufficient. So working in group is inherent, in my view, to this discipline.
But if anything, try to avoid being too many. Like, I would say from 3 to 5 students, it's enough. If you're more than that, then you tend to divide too much the work, and then you don't, usually you have more difficulties to master, you know, the 12, 13 questions. So I would say from 3 to 5, it's the good, ideal number, I would say. But then it's up to you, of course. Because at the end of the day, it's really an exchange with Professor Marsan. You need to be used to have those kind of exchanges more than, you know, this traditional
question-answer dynamic. This is more really an exchange with Professor Marceau. So the larger the number, the more difficult it will be for you to have these kind of exchanges, I would say. Yeah.
Yes?
Since we prepare for the exam in groups, is the possibility, there is possible that the answers are very similar, so will that affect our points or?
No, no, no. The answers are, no worries. There are 12 questions, and it would be very rare that in a group of, let's say, 3 or 4, you all pick the same question out of 12. Huh? Because if you're 4 people, one will come, usually the exams last for a week, one will come on Monday, Tuesday, you put your hand, it would be very rare, and I won't remember, and I don't know who are part of the groups. It's for you.
And also it's not mandatory, it's recommended, because
Yeah.
it usually works better in general, but if you want to work alone, it's perfectly fine as well.
You can work alone, 2, 3 people work alone, and then you sit together and you compare your response. But believe me, it helps to have someone else's perspective or suggestion. It helps your understanding of the questions and response. All right, so you're always welcome to ask more questions on that. So 2, 3 words on what we will look at, and then we will go through the syllabus together just quickly. Then we'll take a break, and in the second part of the class, I will immediately plunge into the course, so you have an idea of what we do. So this course is about WTO law and practice, and as you may know, the World Trade Organization is a treaty that created a new organization that started working in 1995. But it's a treaty that basically included an older treaty called the GATT. And what was the GATT? It was a general agreement on tariff and trade. Now, just out of curiosity, how many of you have ever done a course on GATT or WTO or international economic law? So, yeah, about 10? Yeah. So, sorry for those of you who know all this, especially the first or second classes. Good for you. This may be a bit more practical. So, historically, the GATT was not a perfect treaty. And this is all things long time ago, but I'm one of those who believe very much in history, and it helps understand where we stand today. So, the war goes on, the Second World War, as you are aware. I was not there, you were not there. And during the Second World War, the Allies, that is UK and US at the time, and Canada, start rethinking the international structure, the United Nations, also the economic organization called the Bretton Woods Sisters, the IMF, that is responsible for monetary issue, the World Bank, responsible for investment and development, and trade, which was to be the International Trade Organization. And the International Trade Organization is an amazing treaty that was signed, led by the US, who then refused to ratify it. The ITO, also called the Havana Charter because it was signed in Havana, Cuba, I mentioned is amazing. It includes all sorts of provisions, some of which have not yet been repeated in treaties today, about international companies, about recourse to the International Court of Justice. Already we talked about services and all that. In that ITO, in that Havana Charter treaty, the other fundamental aspect, because it's coming back, is the link with labor standards. So it was the Vienna Charter on trade and labor standard. Why? Because after the war, there was a need to give jobs to people. There was a need to rebuild Europe and more. And already at that time, and I'm talking 45, governments tried to take into account labor and trade. Part of the ITO was a chapter, Chapter 5, called Commercial Policy. What is commercial policy? That's what we'll talk about in this course. That is the actions by governments to try to help their industry and favor trade or restrict trade. This Chapter 5 on international commercial policy was also called the GATT, the General Agreement on Tariff and Trade. Why the focus on tariff and trade? Because at that time, it was a mess in Europe. The government said, wow, we really need to increase exchange and make money and make trade. And what appeared to be the biggest restrictions on trade, and we will look at that, were tariff. What's a tariff? It's an amount of money that governments collect at the border when they receive goods from abroad. You know, governments, states are sovereign. They do what they want. But they sign treaty where they limit their sovereignty and they make promises. So the first promise, and we will look at that a bit in more detail, the first promise they started discussing is the maximum amount of money that we call tariff or duty that they will collect on goods from their neighbors or otherwise. General Agreement on Tariff and the other few rules of the old GATT are rules to make sure that these tariff promises are respected. We will see more of that. By the end of the day, you will already have, by the end of this course, an idea of what is a tariff, how it acts, and what are those other regulations. So the GATT was signed on a provisional basis in 1948, waiting for the finalization of the ITO. And then the UN was starting and all the other organizations. But then the tensions between EU, well, not EU at the time, Europe and US started, in part because US had given a lot of loans to the UK to help them during the war. There was a Marshall Plan to reinvigorate Europe, and the US Congress worried about putting in place and enforce the Havana Charter or the ITO because of this reference to labor standard. And if you read the press of the time, you even have allegations, whoa, labor standard, Europeans and their holidays, blah, blah, blah. So the US backtracks, refused to ratify the ITO. The other governments decide not to ratify. And then the GATT, that was not really supposed to be alone, that was put in place on a temporary basis, because you will see it's fairly minimum, remains there alone and will be the only multilateral treaty on trade between states until the WTO. There are, of course, some free trade agreements and some specialized. I'm talking the big. So what is the WTO? Well, it's a new treaty. It's not an amendment of the GATT. It's a new treaty, and I usually say that's the way it was built. They took a big bag, the government, and they say the GATT is really handicapped. It only deals with tariff, but there are tons of problems much bigger. Subsidies, intellectual property, agriculture. So they put this big bag that they call WTO, and they took the old GATT handicapped agreement, put it in the bag, and started adding things, and that's what we will look briefly today and throughout the course. Closed the bag, said this is now the WTO. The GATT deals only with at the time what was trade in goods. When you trade shoes, cars, airplanes, whatever. We will not speak much about trade in services, although in today's reality, it's extremely important in the economy. What's trade in services? Well, international service would be banks, insurance, lawyers. This class is trade in services. The service is education. Foreign students, me, I'm Canadian. In Switzerland, it's a perfect example of international trade in service, which is service education. We will have only one class explaining how the basic rules that we learn about what happens when country A exports cars to country B and B doesn't want the car or collects tariff as it happens today. So the focus of the class is more on trade in goods because it's easier, but also it's the basis of all the other sector. So this is the beginning of the WTO, which will produce many judgment. Because one characteristic of the WTO is that it put in place an extremely powerful dispute settlement system. This is where I worked mainly for years. A very powerful, why? Because any country who believes that another country does not respect the rule can only raise its flag and they start a dispute even if there's no trade between the country complaining and the country at fault. There is no police in the WTO. The police are the states themselves checking each other. And because the system is automatic, mandatory, compulsory jurisdiction, there was a first instance that we call panel, functions like arbitration, and then an appeal court. That is a court only in law that will issue a lot of ruling that will be fairly used also in other tribunals and all over jurisdiction. This appeal court has since disappeared. Disappeared because the United States, inter alia, not only but mainly, was losing cases in areas where they argued that the appeal court was making mistakes in not reading the treaty the way they think it should be read. And they basically invoke international law principle. I'm a state. In order to be subject to dispute, I need to consent. I never consented to that sort of mechanism. You will see where they lost. But this appellate body process has disappeared because the judge were nominated for 4 years, renewable once, and the WTO functions generally with consensus. You know what consensus is? It's not unanimity. Consensus is the absence of objection. It's the way the WTO functions. Although there are very detailed rules on voting, they're never used. It works this way. One country says, oh, I suggest that we don't have meetings on weekends, for instance. Silence in the room? Good, adopted. We say silence is gold. So when it was time to replace the judges or adopt a budget for them at the appellate body, it was suggested, what about if we have this person as judge or that person? And US objected and has been objecting for 6-7 years to the extent that there's no appeal anymore. What does it mean in practice for the dispute settlement system? And it explains why I modified a little bit the program. What happened is that the treaty at the moment still says, after you had a judgment from the first instance, the panel, we call them, you can go on appeal. So people, governments who lose a case, because the first instance still works, They want to go and appeal, so they says, yes, me, I don't like this, I lost the case, I will appeal. Okay, but there's no appeal. There's no court. So we call that an appeal in the void. There are now over 20 appeals in the void. That is, these governments, they have a judgment of first instance, but nothing on appeal. So the interest for dispute settlement system has gone down importantly. At some point, I remember about 7 years ago, the WTO was running 43 disputes in parallel. Now there's 7 per year. So it doesn't mean that the WTO has lost its relevance, because in my view, the WTO has never been so busy. And you will see that. Because WTO is about trade. That is, when a product is exported from country A to country B, maybe country C, it's about trans-border. And for instance, during the pandemic, when the pandemic started, Kazakhstan, the first country, put export restriction on its food, prohibited its people from exporting abroad. Germany did also similar things with masks, with respirators. Each country banned things to leave to protect their own people. So governments started panicking and said, wow, with all these export restrictions, especially in Europe, where they don't necessarily have all the agriculture needs for all the population, they went to the WHO, the World Health Organization. They said, there's a pandemic, this country is putting export restriction, this other country doesn't want to send me their masks, they're blocking their companies, what do we do? And the World Health Organization said, well, I'm sorry, we have doctors and nurses here, no idea what to do with border problems. So this was shift to the WTO. The previous DG, Azevedo, said, yeah, come here, we are used to check, and we will help you, and we'll start mapping the restrictions on products that are necessary for all of you. Then supply chain issues started. People wanted to buy whatever, things that have nothing to do with the pandemic, including cars. And then bits and pieces coming from different countries were stuck on boats, were stuck there because everybody was sick. There was no organization responsible for supply chain before. So they said, you, WTO, you're responsible for cross-border, so you'll deal with that. Even during the pandemic, Médecins Sans Frontières and the nurses, you know, in Switzerland, 30% of the nurses come from France. So we had to invent a mechanism so they crossed the border. So all this was the new role of the WTO, and climate change, for instance. A lot of countries, and you may have read in the press now, EU is talking about CBAM. A lot of countries worry about climate change. They want to deal with the problems. Some have started saying, when products arrive from a country that doesn't do what they're supposed to do on climate change, according to me, I will collect money on this product. So where do you talk about that? Countries wanted to talk about it in UNFCCC, and some said no. So the WTO, in fact, it's the EU, started talking in the WTO about environment and how we need to connect trade with environment, and that environment, by definition, like everything with digitalization, things cross-border all the time. So the responsibility of the role of the WTO, I would say in a short sentence, that used to be a big focus of judges and adjudication has moved to this forum where now they discuss different things. And for instance, at the last COP, it was decided that 5 international organizations, the World Bank, the OECD, UNFCCC, UNCTAD, ITC, and WTO would sit together and find a price to CO2, so that all countries would know and the lead was given to WTO. And a lot of people said, WTO, who knows anything about climate or environment? And the answer was no. This is where governments are used to talk about border measure and taxes and things like that. So the role of the WTO has changed. So there's less dispute, if you want, but this has been compensated by another role in facilitating discussions or governance. Now, I'm saying this because in order to respond to your needs, because you belong to the future, I used to have 12 classes where for each class you had 4 or 5 cases to read about the rules that I explained. I modified that. Reduce, importantly, the reading of judgments and cases, but focus, again by theme, on new areas. So, digital trade. This is also discussed here at the WTO. And many people say, there's no expertise. Yes, but it's cross-border, so it's better there. Climate, as I mentioned. So the second half of the course, if you want, is organized differently on new issues, and we look at how old rules negotiated in 45, 43, 45, 47, old rules of the GATT that were written for goods have been now used, because there's nothing else, to deal with new sort of products, digital, and new sort of problems. That's all I was going to say for the moment. We have 5 minutes before 1 o'clock. Let's go through a little bit quickly the syllabus, and after the break, we'll start the real history and some of the rules. And I'm telling you, if I do a good job, when you leave at 2 o'clock, you will already have an overview of the course, because today I'll explain the main, very generally, the main rules and the main exceptions. And the rest of the semester, we'll just review those in more details with case law. Any question? So, any question, Felipe? Okay. So, this is the first class, and we'll continue a little bit. We'll look at those basic principles together today and come back. The second class will look at what I call the 4 basic market access rules. What's market access? It is when a company exports goods in another country and the importing country restricts importation. I don't want that, I'm scared. I don't want GMO food and things like that. So market access rules, that's next week. The following week cover the exceptions. For instance, there's a set of exceptions: public morals, protection of the environment, protection of the health. And the appellate body said that the exceptions are as important as the rule. EU, for instance, said, I don't want GMO food. They block food coming from Canada, US, the New World, if there's GMO. Muslim country can say, I don't want alcohol. It's prohibited. No problem. If you're coherent, you can block alcohol. So, in fact, there's a lot of things that are blocked, and it's legal, because the appellate body mentioned that the exceptions are as important, and that non-trade concerns are as important as trade. And governments, they don't deal only with trade. They deal with human rights. They deal with environment issues. They have all sorts of obligations. And that's one big difference between the old GATT and the new WTO. And all this is because of a legal issue. I told you that the WTO big bag was created, and they took the GATT, the old GATT, all the principle, and you will see they then invented more rules, but all based on this GATT. But one fundamental difference in the preamble of the WTO, it has added in 93, December, that sustainable development is one of the goals of the WTO. Not only maximization of profit or development or expansion, sustainable development. In the first dispute, one of the first dispute, the appellate body said because of sustainable development that is now an objective of the WTO, you must read the exceptions of the old GATT differently. And these exceptions are equal to the rules. And governments can give priority to non-trade if they respect the conditions. That's what we will look at in this third class. How the exceptions are now very important in giving policy space to WTO members. And that's a bit funny, because one of the most sort of green organization now is WTO, in the sense that it recognized the right of governments to give priority to green, health, and all that. But I would say, in a few words, so long as you don't lie. Why? So I'll give you just one little thing and we'll take a break. One real story. A few years ago, Thailand decided to ban cigarettes from the United States. And they get sued. This is under the GATT. And they saw smoking is bad. The World Health Organization was very impressed because there was no non-smoking policy at the time. So there's a dispute at the time at the WTO, and then questions on Thailand. You ban cigarettes from the United States, but you accept those from Argentina. Oh yes, but the Americans annoy me. Yeah, but you invoke the exception for protection of health. What's the link? Ah, well, maybe Argentina cigarettes have less nicotine. Fine. Well, then why don't you have a regulation that says in this country, cigarettes should not have more than X nicotine? You don't make distinctions based on the origin. It's a club. The GATT was founded by the British. It's a club. So within the club, you treat each other well, but the same, unless you have a justification. And the questions continue. Thailand, you also have domestic production of cigarettes, and you give subsidies to your producers. How can you tell me that you don't want your people to smoke? Well, it's because really, the truth is, and it's always like that, they have good intentions, but this was done to help their industry that had difficulty. Most disputes that concern these non-trade concerns are like this. Governments block trade, but they do it for a non-trade consideration. They're entitled, but they're not coherent. They're not consistent. I don't want this, but they accept the same from another country. So it's 1 o'clock. I suggest we stop until 1:15, and we'll continue to go down the syllabus and start the history a little bit. Questions? No? So we meet in 1:15. We start. Please, 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 please. Yeah. So I mentioned the third class is about the exceptions, and I generally spoke about the exception for the protection of health, but there are many more: environment, morality for human rights, all this. These are all new ways of reading those exceptions, which before the WTO were never used. The fourth class, and I think somebody came to see me about readings, basic readings. Where is the student? So what's your question? Okay. So the way we proceed here is to look at a few cases. The basic difference is that a lot of the readings that are on the syllabus have been removed from Moodle to have less, and we put a few more recent, especially in the sort of, not, how do we call that? Not mandatory? Additional reading. So there is where there's a lot of difference. Also, we used to use a book as basic book that had a lot of cases with a focus only on disputes. So in the Moodle now, or is it in the Moodle, we have put this new book that was just put in place by a professor at the Graduate Institute, by Jennifer Hillman Gao, a Chinese fellow. So this is a book where you have access for free. You need to register to have access to these books. But both this book here, Van den Bosch, and the one on Moodle are just taking you to cases. The advantage of this syllabus is that I have identified in advance which paragraph of each judgment you should read. Some of you with common law background are used to read mountains of cases, those with civil law background a bit less, so that's why we have point to the paragraph. None of those reading are mandatory. They're there to help you understand and add to what we learn in the class. And as I mentioned, the first half will focus, half of the course, 6 classes, or so, on disputes for the principal, and the other half is more on new issues: digital, environment, human rights, labor, all these things. How do they match with trade? And for this, it's not about cases so much. All right? So, another exception that I'm sure you've heard of is security. There are conditions, there are disputes. We will look at that. Technical regulation to trade, SPS, international standard. That's also very important. In WTO, we negotiate tariff, and we try to avoid disputes. We don't negotiate international standards. But there are lots of international organizations, the World Health Organization, Codex, that develop standards. The standard for how you should make cars, how you should make this so it's not dangerous, how you should not put plastic in children's toys. All these standards are negotiated outside the WTO. How do they connect with the WTO? And you will see there's a very important provision that says, for instance, when a country decides to follow an international standard, negotiated, that exists outside, when they decide to follow that standard and they respect that standard, that's okay for WTO, even if they restrict trade. So it's true that WTO is about increasing trade and facilitating trade, but you will see there are lots of situations where a country has the right to block trade, and standard is one of them. There are, however, efforts to multilateralize standard, and this started in the 70s with, for instance, toasters and plugs. Just in Europe, you have different plugs. So a lot of producers ask their country to ask other countries, we should sit together and harmonize, because me, when I make a toaster or a television, I would like to have the same plug for all countries where I export my stuff. We should harmonize standard. The answer was, well, we won't do that in WTO, there's no expert, but we will support that. You do that outside the WTO, and here in the GATT at the time and now the WTO, if you follow those standards, you'll get the WTO blessing even if it restricts trade. So we will look at that in a bit more detail. General standard, general requirements for health, for SPS, food or other. Subsidies in agriculture. There are rules on subsidies that did not exist before. What can you do? Can you use subsidies? And what do you do if you're a poor country that cannot give subsidies to its companies? During the pandemic, for instance, in Switzerland and other rich countries, those restaurants that had to close and everything were given a bit of money by governments. Developing countries said it's not fair, we cannot give that. What are the rules? And are there different rules for subsidies in agriculture? Very important in a country like Switzerland or Europe. And the answer is yes. There are special rules where subsidies for agriculture, if it is for consumption domestically, it's okay. But if you use subsidy to export and then destroy the market abroad, it's not okay. So we will look at the general rule on subsidies and the specific for agriculture. We will look at what is called anti-dumping, countervailing duties, safeguards. What's that? These are rules that allow a government to say, I don't want all these products from abroad. It threatens my domestic industry too much. I need a break. 4 years, nothing from that country, or only a certain amount. Or you gave illegal subsidies to your products. So when the product arrives, it's very cheap because the government of origin gave subsidy, so the product, the table, the chair, the cars, can go for sale at very low price. The WTO says you are entitled to raise the price of products that arrive illegally subsidized. We will look at those rules as well. The other class after, the dispute settlement system. I'm telling you it's not working well, but we will still look at the steps and the procedures. Intellectual property, very important. Why? Because before the URI round, there were 3 problems. And allow me to go here. I'm jumping to what I call the legal structure of the WTO, and you will see we go to this legal structure often. So that's the WTO. It's one treaty. You will see often I talk about the agreement on agriculture, the agreement on subsidies, the agreement on this. We should not do that. They are called agreement because when the negotiations started, there was 15 different working group of negotiations. And they were not put together. The US did not want to have a formal international organization. They wanted this to be closer to a contract where they could block each time. They said yes the last year in '92. So what was done with the result of those bits of negotiation is that they created one treaty called the Agreement Establishing the WTO. It's very short, 10 pages. How do you become a WTO member? How do you vote? How do you leave? How do you pay? All the rest that was negotiated became annex. Annex 1A, Annex 1B, Annex 1C. What is Annex 1A? It's the old GATT that I mentioned. And all these new agreements, what do? They develop the provisions of the old GATT. So we will talk a lot about the GATT in this class. Don't think that it's a waste of time or it's outdated. Many of the existing disputes or tensions involve always a provision of the old GATT that is quite general, and then more specific details in one of those agreements. This is the agreement on services and intellectual property. Dispute settlement is described here horizontally. Why? Because in WTO you can say, I start a dispute because you violate this and that and this and that and this all at the same time. And if you lose a case, there are sanctions, automatic sanctions, in all these areas possible. We will look at that. But the reason why I say the TRIPS agreement, intellectual property, is important, it's called the Trade-Related Intellectual Property Agreement, is the grand deal that was made between rich and poor countries. So, for example, agriculture. A lot of the developing countries, in particular from Latin America, wanted agriculture products to be part of the normal rules. If you read the GATT, and we will read the GATT together on a few occasions, there's no distinction. It talks about products. Everything is included. In fact, the case law said that internet is a product. But this was just a few years ago. But in practice, because of protectionism, agriculture products were never subject to the normal rules. And agriculture products were not part of the rules. And textile products were not part of the rules. So this is not the updated version, Felipe. We have an updated one where we see clearly textile products struck out because it's an agreement that was there only for 10 years. Asian countries produced a lot of textile, but there was a lot of restrictions. And because there was no dispute settlement system, there was no way out. So, the grand deal of the EU round is the following. Latino wanted agriculture, so they were told, okay, we will bring agriculture product within the WTO, and we will even try on reducing subsidies to agriculture. This was not only Latino, big agriculture country, New Zealand, Australia, Canada, they produce easily. There was, of course, resistance from Europe, from Africa, who liked to receive things from Europe, but still, this was the deal. The other deal, to please Asian countries, is we will also make sure the textile products are not subject to restrictions. In exchange, the rich country said, we are fed up that developing countries copy everything we invent, and they refuse to join the WIPO Treaty, the World International Property Organization. So the governments took all the treaties in WIPO and copy them in the WTO. So when you read the chapter on intellectual property of the WTO, it says, WTO members are bound by Article 1 to 100 to the Berne Convention, XYZ Copyright Convention. So this was all repeated in the WTO in exchange. And finally, services was sort of agreed. Remember, when this was negotiated, internet did not exist, but services was starting to grow, and both rich and poor thought that it should be there. So this is the sort of legal structure, will come often, but what we do in this class a lot is to look at those provisions here. What's the GATT 1994? It's the old GATT of 47 plus 50 years of life. Those who do EU law are aware of the concept of EU acquis. This is GATT acquis, we call it. Decisions adopted, there's not that much, but The life of the GATT since 47 is now the components of what composed GATT 1994. So let me go back to the syllabus here. So trade and service and intellectual property, we won't talk that much, but you cannot do a course on WTO without being at least aware you're in Switzerland, very strong actor in intellectual property, and of course in bank, education, services, insurance, all this is trade and services. Preferences, regional agreements, and new agreements. So there are rules, you will see, that allow rich countries to treat better imports from developing countries than the other imports. We'll look at that. Regional trade agreement. How do you fit Europe? EU is a member of the WTO on its own. And each EU state is also a member. Now, artificial intelligence, etc. How do you deal with new technology with those old rules? And trade and environment, climate change and everything. This is, most of the disputes are about related things. And finally, the rest, labor, etc., etc. And it's always the same. I speak mainly, but you're all welcome to speak and intervene. And we'll go one theme by one theme. There's a break in the middle. We'll have a review class. And now I would like to do with you looking at the four main sort of rules and exception briefly. Next week, it's going to be a bit more detail. But before I start that, do you have any questions? Yes?
So you mentioned that the WTO settlement body is not so functional as it used to be, in view of the fact that there are just a few cases before the body. So I'm wondering that the recent FTAs have been fashioned after the WTO. And case in point is the African Continental Free Trade Agreement, which came into force in 2018. The provisions of the agreement have also been fashioned after the WTO. In fact, the dispute settlement.
Yes. What's your question?
I'm wondering, if this is the current trend, that, the WTO dispute settlement is not so functional. So I'm wondering why recent FTAs are still trying to fashion, their dispute settlement mechanism.
The dispute settlement system of the WTO doesn't work because the appeal has no judge, because the US did not like the ruling. But you've done international law. All countries must consent to be sued in international law. You need to agree that the International Court of Justice will judge, for instance. In the African Free Trade Continental Agreement, it's different countries. If they agree with the appellate body of Africa, well, there won't be a problem. Why is it that everybody copied the WTO? It's because it was doing very well. But then suddenly, it started going poorly. So, we're going to go, I'll do it on this here. Can you close the, please? I have to change the legal structure. So I hope you can see, because many of you are far, and it's easier if I do it with you on the blackboard. So we will look, before we stop, at those four main axis rules. And you will understand the logic. Why is it that they focus on tariff? And what are the other rules? And I apologize, I hope you can see So I will always take something simple, the country A and the country B, to explain that. This is a border. And this is a table. A table that is produced by companies in country A. And these companies, they want to export their table to country B to make money. No problem. States are sovereign. This country, if there was no GATT, and now I'm back in 45, the basic market access rule of the GATT, this country can say, I don't want the tables. Or these tables, when they arrive, I will collect a very high duty. Let's assume that this table has a value of whatever, 10 euros, $10. So this country, for instance, would say, I will collect 500% duty on this table, with the result that this table at $10 goes, you need to pay 50 at the border, a tariff of 500. So the table will go for sale at 60 here. You follow me on this? Well, assume that this country also has producers of tables in its country. So these producers are very happy. They lobby the government and they say, oh, you should collect much more than 500. I don't want to see those tables. So the first provision, basic, and we could look at them in any order, is Article 2 that says, in international trade, you should try to limit your tariff to favor trade. And when you make a deal to limit, you write this deal on your national schedule and you respect this deal. How is a deal made? This way. Imagine you represent country A. You're the diplomat of A. And you go to B and you say, listen, I export table to you and you've been collecting 500, sometimes 600, sometimes 700. Why don't you promise me not to collect more than, say, 300? Never you'll go more than 300. Of course, the domestic producers that hear about that will go to the government and say, don't accept this deal. I don't want the tables. You should not make a commitment or make it very high. Of course. But, and this is where trade comes, A tells B, if you promise not to collect more than 300, when you send me, for instance, cars, shoes, whatever product they trade, let's say, I usually say shoes, I have been myself collecting tariff on your shoes. Tariff that vary from 200 to, let's say, 500. The WTO never gives you a tariff level. It just says, sit in a room, make a deal, and respect it. It's still the way it works in the WTO. You get in some rooms, you have two countries face to face. So what is the deal? Why is it table and shoes? I don't know. It's because you export a lot of table there, so you, as a diplomat, will call B and say, why don't we meet tomorrow? And why don't you promise me to reduce your import tariff and limit it to 300? That's called a maximum. In exchange, when you send shoes, I've been collecting this and that. So I promise I will never collect more than 300% when you export shoes to me. So governments go back to capital, they check with companies, and the domestic producers say, no, 300, it's way, way, way too low. Keep that at 400. So the diplomat of B will say to here, listen, I cannot give you 300, I need at least 400. In exchange, I know you cannot give me 300, you give me something else. 375. The WTO does not tell you what the number should be. You're alone in the room. There's no secretariat. You decide what your economy is able to cope with, based on how many jobs are given by the table producers, the shoe producers. Let's assume there's a deal. So A managed to convince B, and what's the deal? 400% maximum that B will collect on tables from A, and in exchange, when B sends shoes to A, 375. Okay, that's the deal. It's a bilateral deal. Then, the second provision of the GATT, Article 1, called Most Favored Nation Principle, comes from the club, says, whatever you give to one, you must give to all. So automatically, when the deal is concluded, then it is multilateralized. What does it mean? It means that if the maximum of tariff on table is 400, any country of the GATT that exports table to B will benefit from a maximum of 400, and the same thing the other way around. That's the magic of multilateralism. The negotiations are done by those who want. Usually you go where you export a lot. And the benefits are given to all. So very often you hear people saying, oh, it's bad because developing countries are not very active in bilateral negotiation. It is true. Unless you're big producers like Ecuador, very active in exportation of banana. They're poor, they don't produce much, but they export a lot of banana, and they have an interest, for instance, in Europe. So they make deals between their banana and other things. The point is that the tariff negotiation is done bilaterally, product by product, and automatically multilateralized when it's completed. The maximum tariff provided in Article 2 is called a binding. And next week, there may be examples. When we heard about Trump and China and the trade war, what happened is that US has an import tariff on steel of 2% now. And they said there's too much things that come from China, so I raise it unilaterally at 25. China sued US, and US was told cannot do that. There are procedures if you want to modify your tariff level. We won't look at that in detail, but essentially you compensate. Because when you decided to limit your tariff here at 400 and your domestic industry was not happy, because it means stable will come in, you limit yourself, but in exchange, you got an advantage in another sector. And this is why it's so difficult. Because governments need to say, okay, well, I'm going to hurt a bit my producers of tables, but I will help my producers of shoes, and indeed, there are much more job in shoes. And the producers of shoes will go to the government and say, I'll help you at the election next time. Help me, help me. In Switzerland, watch producers want to export their watch all over the world. The country receiving it, let's say it's Argentina, will say, okay, I won't impose a very high tariff on watches coming from Switzerland, but when I export my agriculture products, I want you to reduce. And then the Swiss government says, the agriculture in Switzerland, they're strong. So it's for each government to decide how much they can press on one industry vis-à-vis the other, but then the benefit, that is a maximum, is multilateralized. The other two rules are also fairly simple if you understand them in the context of this tariff negotiation. Article 11, for instance, tells you, at the border, if you want to protect your industry, no problem. You can collect tariff, but you cannot have quotas, quantitative restrictions, or ban. So, if you did not have Article 11, this is what could happen. Let's take our example of tables. So you are the diplomat of A, and you manage to get a deal 400 maximum. So you go back home, of course you're promoted, it's a great job, the unions are happy, the industry is happy, They produce a lot of tables because they know that now they'll be able to sell a lot of tables there. So a boat, a train arrive full of tables from A to B, and at the border, B says, oh yes, 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 I will respect my commitment. I will only collect 400%, but I take 5 tables. B will say, no. I thought that once I pay the tariff, I come in. And the answer is, yes, you're right. As a rule, quotas are prohibited, as a rule. There are exceptions. Muslim country can ban alcohol. You can ban something that is dangerous for you. And you will see all those exceptions have requirements that we described in the Thailand cigarette case is, are you lying? Are you really banning this for health? So that's why there's an Article 11 that tells you, as a general rule, you do not put quotas here. All you can do is negotiate a tariff, but be careful. You may want to protect one industry, but sometimes you also have industries who want to export. And here I describe it simply, 1 table, 2 countries. Well, that's the way it works for all products in all countries who want to negotiate. And why do they want to negotiate? It's because they want to export their things. But of course, they need to make concessions on the import, and it's often different sector. So, 3rd rule, at the border, no quota. Last rule for us today, national treatment. Do you have a question? I see that some people seem to have questions. Yeah?
I want to know that if you have just mentioned that the maximum tariff is multilateral, but if
Is
there-
multilateralized. It's negotiated bilaterally.
yes, but but what about the minimum tariff?
There's no minimum tariff.
For example, there is 200% to 500 to 300%, and what about the 200%?
No. When I said the tariff goes from 200 to 500, is that all countries are sovereign. One day, B says, okay, I collect 500. The next day, I collect 7. The following day, I don't collect any. States are sovereign, they collect what they want. The WTO doesn't tell you. I just use that as an example. This country has been collecting quite high levels on different days. And then this country accepts to say, okay, now on, in the future, I will only collect 300. So there's never any minimum tariff by the WTO. The WTO protects exports, so it says you can, if you promise not to collect more than 300, keep your promise. So if you go to the WTO, you can check each country, what is the maximum tariff they promise to put on this item. And although the deal is concluded bilaterally, it is multilateralized, at least conceptually. There are exceptions, but for you it suffices. The last rule is called national treatment, typical of the club. 50% of world disputes are about national treatment. What is this rule? Or what would happen if you did not have national treatment? National treatment says it's a club. An imported table and a domestic table, if they are similar, should be taxed the same way, regulated the same way, except for the tariff at the border. So, if you did not have national treatment, what would happen is that you have this deal. Of course, here, promotion, you build tables, a boat, a train arrive at the border full of tables. So B will say, okay, I will respect my commitments, I will collect only 300. But imported table can go for sale only outside the town, only on Sunday between midnight and 3 o'clock. So this was a real dispute. Korea had a system where imported beef from New Zealand, Australia, Canada, US, could go for sale only outside the town in little butcher shop, never for sale in supermarket. They sue and they tell Korea, my beef is like your beef, I'll pay the border tariff, But once I'm in, it's a club. Tax, real dispute. EU will sue Japan because in Japan, the soju, their alcohol, was taxed, I think at the time, 5%, and imported whiskey, vodka, 200. EU sues Japan and says, what's this? My booze is like your booze. Are these products like? Korea will say, no, 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 because me, it's 26% alcohol, and then we drink it with tea at the meal. They drink it before. These are not like products. They're not similar. So I can tax them differently. The EU arrived with survey. They went to Korea, Japan rather, survey. You, madam, if you want to make a party and there's no more soju in the shop, are you going to buy vodka or whiskey? Are they interchangeable? And most people said yes. So the answer is since imported booze from Europe and domestic soju are in competition and consumers would interchange them, they are therefore like products and they should be treated the same way and taxed the same way. So the WTO will say to Japan, because in dispute in WTO, all judgment can have only one conclusion. You violate. Do what you want, but change the violation. There's never any money for the loss of trade. It's essentially a prospective system. So, for instance, in the case of this soju, Japan domestic tax on soju is at that level. Tax on imported vodka is there. So, Japan was told, do what you want. You can increase the tax on domestic soju. You can decrease the tax on imported vodka. Put both in the middle. Don't use tax at all. Do what you want, but respect national treatment. Now, there are very important issues about national treatment, because I told you it's simple. Imported products, there's a border here, and domestic products that are like must be treated similarly on all fronts, fiscal, non-fiscal. Okay, everybody understand that. Very difficult, however, for governments, because people are convinced that the job of their government is to protect their industrial production and their job. But when you sign the WTO, you promise that if you want to protect your industry, you will only do it as a principle with tariff. But there's another issue. If I'm telling you, these are the two products we trade. Are they like? This is imported. This is domestic. Are they like? Yeah. Now, if I tell you this is done in violation of environment treaties and Paris Convention, and this is done in respect, are they like? If this is done by children, 6 years old, not paid, this is done by a machine, are they like? Okay. Now, I told you this was made by children. How do you know when you go to the shop and both are on the shelves? You don't know. There's no labeling obligation on this planet. So, how are they like? The WTO case law has said, well, if consumers treat them like, because they go and they just don't know, and this one is cheap, but often you just don't know how things are made. If consumers would interchange them, and it's often the case, especially in big cities, most consumers, especially if they're not rich, will go for the cheapest. But maybe it's because it's made by children. What the WTO has done that is different from the GATT, it said when you have this situation of like products that is relevant, as I said, for 50% of world dispute, you first look at consumers. Do they treat them like? Yes. So you cannot tax them differently or treat them differently from a regulatory point of view. Often you have, and there are all sorts of regulations. I don't want this to have access to publicity on TV. Why? Because I think they're not like. Are they like? Consumers, are they like? Yes. But what the WTO has done that didn't exist is they said, however, in all situations where these rules apply a priori, you can also, as a government importing, start invoking the exceptions. So what are these exceptions? For today we'll look at mainly those we've talked about. You would say, I agree that this look alike, but this one is made in violation of some environment treaties or Paris Convention or whatever, and it's bad, so I'm invoking measure necessary for the protection of the environment. And therefore, I will be allowed to treat them differently, so long as I do it in the best possible manner. If this is made by children, you would invoke Article 20 that allows government, it says word for word, nothing limits the right of the governments to enforce public moral policies. I don't want that, even if you tell me it's like, me as a government, I know how it's made, I don't want my consumers to buy that. So the exceptions I mentioned have been used to sort of rebalance the non-trade considerations. Same thing for security. This provision is 24, allowing government to sign free trade area, to create EU, where trade between France and Germany is not like trade between France and Canada. They can treat them better, a sub-club. So these are all issues we will look at, and the last one here is that even if all goods are like, you as an importing country, you could say, yes, yes, I made a deal and I promised not to collect more than 300. But sorry, there's a massive increase of tables and my industry will die. I want a break for 4 years. So for 4 years, you will be entitled to either collect more than 300 or have quotas. So these are the 4 basic market access rules, legal obligations to be respected, and 4 exceptions. And disputes are often about that. You block trade, you collect more than 300, you put a ban, I don't want any of that, or I take only 10, a quota. A priori, it's wrong, unless you can justify your action on the basis of legitimate concerns. And remember, the preamble of the WTO says sustainable development is a new goal. So everything you fit under sustainable development can justify a restriction to trade, a violation of the rules. But of course, there's a good faith control. Are you lying? You block cigarettes because you tell me you do this for the health of your people, but you produce cigarettes, you subsidize cigarettes, you import cigarettes from elsewhere. So this is the old GATT, and the new agreement have only developed that further. And I'll finish with one story. Under the new WTO sanitary agreement that is here, this sanitary agreement is a development of Article 20 exception. And here is the story. Australia bans fresh salmon from Canada and the United States, saying that the salmon from Canada comes from the Atlantic waters and they have a disease. It's not a dangerous disease. It's not transmissible to human beings, but it is a disease that can pass to fish, very difficult to pass. So US sues Australia and says, what's this? Oh, your fish has a disease. Well, it's not important. There's still a risk, says Australia. What's the risk, says US in front of the judge? The risk is that if I have American